Civil asset forfeiture is a legal process where law enforcement can take your property, claiming it was used in a crime or gained from a crime, and keep it. True story. It's a law that's meant for criminals, but it's often used against innocent people, and it can seem daunting to navigate the judicial system to get your stuff back. If you find your property is subject to potential forfeiture, you'll have to provide your own lawyer. If you can't afford a lawyer, first attempt to find free or low-cost legal help from the State Bar of Texas or local legal aid organizations. If you can't find a lawyer, don't give up. There are ways to do it on your own. Let's dig in. There's a difference between seizure and forfeiture. Seizure is what happens when the police take your property. Forfeiture is what happens later, after a lawsuit has been filed and a court has decided that the government can keep your property. That means that not all property that is seized will be forfeited. What you do in the time between the seizure and the forfeiture can make all the difference in getting your property back. First things first, who seized your property? A state agency or a federal agency? A state agency, like local or state police, has 30 days from the seizure to file a lawsuit of forfeiture. A federal agency, like the IRS or the DEA, will either notify you directly or they'll turn the property over to state authorities. If the federal agency turns it over to the state, then the 30-day deadline starts to run when the property is turned over to the state. The rest of this video focuses on the state process. If a state agency took your property, first visit or write to the local district attorney where your property was taken and ask for your property back. Be prepared to explain what property was seized, how your property was seized, and where you got the property in the first place. This is a must because it could help you avoid the court process altogether. If the state does not file within 30 days, then you should get your property back. Let me say it again. If the seizing state agency does not file a lawsuit within 30 days of the seizure, then you should get your property back. So how will you know if the state filed a lawsuit against your property? If the state did file, they have to tell you that they filed by delivering a copy of the petition, also known as the complaint, to you in person or by certified mail. In more technical terms, they have to serve you with the petition and provide you with notice of the suit. Did you get notice of the forfeiture suit? If your answer is no, but a suit was filed and you lost your property, either ask for a new trial from the judge in the case, or file a bill of review suit to set the judgment aside. If you win your bill of review suit, the judge will allow a new trial. Now, let's say you did get notice of the suit. Then you must answer the complaint. Count 20 calendar days from the day you received notice. Your response is due no later than 10 a.m. the Monday after that 20-day period. This is very important. Always answer, even if your answer will be late. Your answer should either generally deny all of the claims the state made in their complaint, or deny each specific claim individually. Then you should state all possible defenses you may have against the state's claims. Some defenses available in a civil asset forfeiture suit are the innocent owner defense. Use this defense if you know that your property was obtained legally, or if you did not know that your property was related to a crime. The family violence defense is available to spouses who knew their property was related to a crime, but couldn't stop that crime because of domestic violence against them. The dismissal of criminal charges defense isn't a total defense like the other two, but you can use it when the criminal charges that go along with the property are dropped in a separate court case. If the other charges are dropped, you should include this defense along with innocent owner defense. Filing your answer is a two-step process. First, file your answer either in person with the court clerk or online through efiletexas.gov. Second, get a copy of the document to the lawyer representing the law enforcement agency that seized your property, serving them with notice by certified mail. This person can be found on the state's petition. The court clerk can help you figure out how to file and serve the state. Remember, if you don't file an answer, your property goes to the government. So answer, even if you think you might be late. If the state needs more information, they may send you a discovery request. You can also ask for information from the state. For more information about discovery requests, check out endforfeitureabusetx.org. Are you still with me? Okay, you've gotten this far. Don't give up. Once everyone has the information they need, the court will set a trial date. During trial, the state will try to show that it should get to keep your property. Then you will show, with evidence, why your property should be given back. One way you'll do that is by using the defenses that you put in your answer: the innocent owner defense, the family violence defense, or the dismissal of criminal charges defense. Whew! At the end of the trial, the court will issue a judgment stating who won the case and thus the right to the property. If you lose, well, you know what happens. The state gets to keep your property. But if you win, you get your property back. It's worth the fight. Civil asset forfeiture laws are being reviewed and changed across the country. Contact your representative if you want to see changes in your state. Always remember, you do have property rights, and there are legal resources available to help you navigate the judicial system. For more information, or if you have questions, visit endforfeitureabusetx.org.